All right. All right. We're recording on everything today. Good morning, ladies and gentlemen. A little screw ups here on the computer. A lot of shows on. A lot of channels on. My guest today is Lewis Ewing. I am Clay Douglas. Hello, Lewis. How are you?
Hi, how are you?
I'm doing pretty well. Lewis, tell me exactly. You have been playing with the court systems. I mean, personally, I understand the laws, and I won every small claims court that I've been in. I've won in every one, and a few major courts. I remember walking into a courthouse in Las Vegas where somebody was suing me. I countersued them, and the lawyer looked a little frustrated, and well, he looked at me and he said, "Are you Mr. Douglas's attorney?" I said, "No, I'm Mr. Douglas." Your Honor, this is the defendant. Can't you make him hire a lawyer? Your Honor, if you look at my brief there, you'll see that I countersued. And if you read my brief there, I believe you'll see that I'm perfectly capable of defending myself. And the judge looked at the lawyer and said, "No, I can't make him hire a lawyer." And I won. But what do you do? Tell me again. And tell me how you got into this.
Well, how I got into this was I got tired of paying attorneys to do nothing but lose. First, they blow smoke up your rear end telling you they've done lots of cases like this before. Your case should be no problem, should be simple. So you get to court, you're waiting for your attorney, and he's late. Coming after your name was called, and you're there with no attorney, waiting for your attorney to show up. And then they come in late and ask the judge for a recess. Then he comes back and talks to you and tells you to come and sit with him in the back of the courtroom, or come out in the lobby and want to talk to you. Then he'll tell you, "Well, I read the police report, and it doesn't look very good, but I got you a good deal." "A deal? Well, what kind of deal are you talking about?" "Well, I got you a plea bargain." "Well, does pleading guilty sound like a bargain to you? It doesn't sound like a bargain to me." That's what got me, like, that's it, I'm done with attorneys.
Well, I had that same conversation, and now this was over a pot charge in Texas. Of course, it happened to be a potential penalty of 99 years. So, son, I can get you a deal. You can get by with 7 years. You can get by with 7 years. I can get you 7 years here. Or you could go before the jury and try and take your chances and possibly get 99 years. Hell of a bargain, wasn't it? Wasn't that a hell of a bargain?
Yeah. So I decided to start studying the law on my own and start researching and reading case law and statutes, and started writing my own briefs, and I started winning. I stopped driving with a driver's license back in 1996. And so basically that's where I got my start, was beating traffic tickets for driving without a license or driving while suspended. Eventually I moved on to other stuff like drunk driving, resisting arrest, obstructing a law enforcement officer, DUIs, drug possession. In fact, in 2004, my buddy and I, Kurt Riggin, beat the largest marijuana case in the state of Washington pre-trial. Kurt got busted with 166 marijuana plants that were all over 6 feet tall, of the best purple bud you'd ever smoked in your life, and we beat it pre-trial.
Cool.
In fact, we kicked their butt so bad they ordered the case unpublished, and they ordered the case sealed. And that was the Snohomish County Superior Court cause number 02-1-01835-6. And that was 2004. That case was ordered to be unpublished and sealed. And there's two main reasons why they ordered it unpublished and sealed. Number one, well, the main reason why all the states in the last 4 or 5 years you've seen are arguing that they want to have a 15 or 20 plant limit to constitute a 60-day smokable supply of marijuana is because I wrote a really, really good medical marijuana brief showing that the statute did not state specifically how many plants you could have or couldn't have. Therefore, the supply was unlimited based upon the individual user's ability to smoke. And we came up with a formula, and we made an offer of proof for the court under Evidence Rule 103 that based upon Kurt's ability to smoke marijuana, we offered to do a videotape demonstration of Kurt, or Kurt and I would do a live demonstration smoking pot inside the courthouse on videotape, that Kurt Riggin could smoke at least an ounce a day in less than 8 hours. Well, needless to say, the judges didn't want us stinking up the courthouse smoking pot on videotape in the middle of their courthouse. So
that would look bad. That would look bad to the public in the hallways, wouldn't it?
Yeah. So under the rules of evidence, Evidence Rule 103, the offer of proof rule, that's the same rule that Johnny Cochran won his case with. If the glove doesn't fit, you must acquit, was an offer of proof for the record. And offers of proof are very powerful. It's a way of making the record. And under the annotated case law interpreting the rules of evidence, the only way they could deny you making an offer of proof is they have to stipulate to what you're saying is true. So they took that in their advisement, and based upon the mathematical formula we came up with, we made a showing that 166 marijuana plants was not enough to constitute a 60-day smokable supply at any one time, with Kurt's ability to smoke at least an ounce a day.
Now, there's a case going on right now in Texas. It's been around the internet a little bit. I don't know if you've seen it or not. A kid got busted in Texas with a little bit of pot, and he claimed it was a medical marijuana. It was for medical marijuana, and he's facing 99 years.
Well, the problem is these people are relying on attorneys, and most people, that's all they know, and they're too scared to go with anything but attorneys, and that's where the problem is at. I have an ultimate user flyer for Washington, Oregon, Idaho, Utah, Nevada, North and South Carolina, Illinois, and I'm working on the rest of the states, showing that you can lawfully possess marijuana. And nobody who has any of my flyers has ever been busted for possession of marijuana in any quantity, including my ex-girlfriend with half a pound of weed in the car by the Pierce County Sheriffs in Tacoma.
Now, what does this flyer do? I mean, if there is no corpus, correct me if I'm wrong, if there's no corpus delicti, if there's no victim, there is no crime. Isn't that correct? And there's nothing in the Constitution that gives the government the right to outlaw the plant of their choice.
Well, that's something I am going to write up a legal brief based upon religious convictions, because the Bible does say eat the seed is the meat, and He gave us all the herb-bearing, seed-bearing plants, He gave us dominion over the land, so they can't interfere with that. It's a natural right. But the main thing that my Ultimate User Flyer does, my Ultimate User Flyer exposes the law, showing that the marijuana laws, or actually not just the marijuana laws, all the drug laws, only apply to somebody who is a drug dealer. There is a statute in every single state that prohibits you from manufacturing with intent to distribute. There is a statute that prohibits you from possessing with intent to distribute. But there is no statute in existence that prohibits you from manufacturing or growing with intent to smoke it yourself, and there is no statute that prohibits you from the mere possession or possessing with intent to smoke it yourself. And I'll read you Washington statute. It's 69.50.302, subsection 3.3. The registration requirements clearly reads at subsection C, the following persons need not register and may lawfully possess controlled substances under this chapter. ... means I skip section 1 and 2. I'll go down to subsection 3. It says an ultimate user or a person in possession of any controlled substance pursuant to a lawful order of a practitioner or in lawful possession of a substance included in Schedule 5. Okay, now if you show this statute standing alone to any attorney, prosecutor, or judge, every single one of them will lie to you and say, oh, no, 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 see, you have to have a prescription from a doctor in order to be an ultimate user. No. Let's look at that statute again. Let's go up to subsection C. It says the following persons. It's worded in the plural with an S on the end of person. It clearly refers to two classes of people that need not register, and conjunctively, first of all, you don't need to register. Secondly, because it's worded with the conjunctive word and, it means both. Need not register and may lawfully possess controlled substances under the chapter. You go down to subsection 3, it's worded with the disjunctive word or. Okay, or is a disjunctive word, which means you have a choice of one or the other. Would you like to have an apple or an orange? You have a choice, clearly, one or the other, but not both. Versus, do you want an apple and an orange? I'm giving you the choice to have both if you want to. Okay, so now subsection 3 says ultimate user, an ultimate user, or a person in possession of any controlled substance pursuant to a lawful order of a practitioner or in lawful possession of a substance included in Schedule 5. So now, this begs the question, what is an ultimate user? Well, the feckless pettifoggers, the Jewish attorneys, or the wannabe Jew attorneys, they hid the definition of ultimate user in another statute, which is 6950-101 BB. Ultimate user is defined in quotation marks. Ultimate user, quote, means an individual who lawfully possesses a controlled substance for the individual's own use, or for the use of a member of the individual's household, or for administering to an animal owned by the individual or by a member of the individual's household. And me being the smart aleck that I am, I wrote on my flyer here, Washington law allows me to get my dogs and cats high if I want to.
Packy, come here, man. This is good news for you, man. They love finding a joint on the floor and eating it. Do you know?
Oh, they do. Yeah. No.
Come here, Packy. Yes.
Cats like marijuana just as good or better than catnip.
Yeah. This is my Harley riding pot smoking joint eating chihuahuas here.
Now the equivalent statute for the registration statute.
Not yet.
In Washington, the federal statute is 21 U.S.C. 822 subsection 2C3, and the equivalent federal statute for the definition of ultimate user is 21 U.S.C. 802 subsection 27. But I do find over the years they're trying to hide these statutes or amend them to say things that they didn't say before. But what I read you on my Ultimate User flyer is the older version. I haven't looked at the newer version for a couple of years. But here's the thing. In order for them to charge manufacturing with intent to distribute or possession with intent to distribute, they have to prove the essential element that A, you actually made a distribution or transfer or sale, or B, that you attempted to distribute, transfer, or sale. And I've got the case law that lays out it has to be more than me and you. Okay? There has to be 2 or more people. So if the cop catches you driving by yourself and finds an ounce, a pound, or 10 pounds of marijuana, you don't want to say, oh, that's not mine. That somebody left it in my back seat. And come on, you know you're lying. They know you're lying. Instead, people just need to be armed with the law and stand up tall and be proud and brave and say, hey, this is my shit. This is my stuff. Leave it alone. You take this stuff from me, I'm going to call your supervisor and demand an accounting. You know, I spent good money on that stuff. It's mine.
Well, you know, okay. I went to a doctor.
the
Go
cops
ahead.
will try to steal it from you.
Of course, of course. That's this whole thing. Now, I wrote a book 40 years ago, Louis. I've just got it back in the computer. I'm just reworking it. I updating it a bit. You know, I had to take out the IBM Selectric typewriters in the office and replace that with computers. And but it was about the United States after a new president came in, somebody like Ron Paul, who agrees with us on the constitutionality of the drug laws, and they legalized, they abolished all laws against victimless crimes. I wrote that story 40 years ago, and I left it, since the states have a right to choose. I said, well, 4 states kept the same laws that they got to do: Texas, Oklahoma, Arkansas, and Mississippi. And they were still pulling people off the interstates and throwing them in prison in Texas in my first novel. But in my since then, I've discovered that the CIA is bringing all of the cocaine, all of the heroin of the CIA and the Mossad, the intelligence agencies that don't work for us, they work for the bankers. They're bringing all the illegal drugs. You know, it's just like it's prohibition all over again. They made our farmers and ranchers into criminals. They bootleggers and moonshiners, and they're doing the same thing with the drugs here. If you could just go down on the border, and you had guards on the border, and you could go to a table on the border and trade a little bit of your wheat or corn for some Mexican pot or cocaine, we wouldn't be spending $50,000 to house and feed millions of people. $50,000 a year to keep somebody in a friggin' prison. What the hell's that? I mean, that don't mean that means that like Ayn Rand said, government has no control over honest citizens, so they have to make criminals out of us. Is that what's happening here?
Well, that's exactly what's happening, but there is a difference between marijuana and alcohol, okay? Basically, during the times of alcohol and prohibition and the bootleggers and moonshiners and Al Capone, the Constitution said that the sale of alcohol was prohibited. So basically, they used the police powers, kind of like how they're using the police powers now, to harass the public until there was a large public outcry because everybody wanted to drink, everybody was drinking, and, you know, women wanted to use an excuse, oh, I wouldn't have had sex with you if I wasn't drunk. Yeah, right, okay. You use alcohol as the excuse, I don't care as long as we party. but the fact is, the Constitution said that the sale of alcohol was prohibited.
All right, hang on, I lost something here. Let me see what I lost.
Okay, well, you read the Constitution, and where does it say the sale of marijuana has prohibited? It doesn't. So we don't need to have a constitutional convention to amend the Constitution to make it legal to sell marijuana, because it's not illegal to start with. What happened is we have all these fake Jews, attorneys, who've infiltrated our state legislatures and Congress,
company trouble. Your call cannot be completed.
and they have snuck in legislation to change the wording of the statutes to fool you into believing it says something that it doesn't say. But clearly, when you get charged with a drug charge, it's manufacturing with intent to distribute or possession with intent to distribute. And what they did is they put a presumption in the statute. They charge you with the offense, and then they leave it up to you to figure out what the defense is. Well, what does intent to distribute mean? Do I know, am I a mind reader? Do I delve in the occult? Or am I a sorcerer? Or do I practice voodoo? How would I know what your state of mind is any more than I know what your state of indigestion is? Why do they put a rebuttable presumption in the statute, which is technically kind of unconstitutional, because the burden of proof is always supposed to be on the prosecutor. So it kind of illegally shifts the burden, unless you understand the wording of law, it shifts the burden illegally to the defendants. I shouldn't have the burden of proving myself innocent, but that's the way they created the statute. manufacturing with intent to distribute. So now I have to come forward and prove that I had no intent to distribute. And the way to do that is to say, hey, this statute only prohibits manufacturing with intent to distribute. I had no intent to distribute. You caught me growing plants, but that's not a crime. There's nothing in the statute that says I can't manufacture or grow myself with intent to smoke it myself. And the same thing with possession. This is my stuff. This is my shit. I bought it for myself. This is, I'm not selling it. And officer, do you see anybody else here sitting in the car? Well, no. Well, officer, is it true that you wear a microphone on your shoulder lapel there and that you're actually recording everything I'm saying? The cop's going to say, how did you know that? And you say, well, Louis Ewing told me. The cops actually they have a small microphone that is clipped to the lapel on their shirt. And when they come to your window, they're actually recording everything they're saying to you without telling you. So, officer, I would like you, to lean a little closer because I want to make sure you pick this up. Do you see anybody in the car? Yes or no? The officer will say no. Officer, did I try to sell you these drugs? Well, no. Officer, did I try to give you these drugs? No. Officer, isn't it true that I told you I bought these drugs for myself, that I'm the ultimate user? Well, yeah. Now the officer's going to ask you, why do you have a scale? And you say, well, I'm tired of being ripped off by the drug dealers. I want to make sure I'm getting what I paid for. Then the officer's going to say, well, why do you have, 4 or 5 or 6 bags?
We're sorry.
And you're going to tell the cop, well, that's the way the drug dealer had it packaged. He didn't have a larger package for the larger quantity, and he told me that if I bought this much for this price, he'd give me a better deal. So I bought all 6 baggies at once rather than 1 baggie. He gave me a really good deal. And I can't smoke it all at once anyway, so it makes more sense, for me to buy this stuff bagged up in 6 different baggies so I can smoke it over a couple weeks. And
now let me ask you. Let me just kind of take you on a sidetrack here. One of I've identified a few main problems that need. We're talking about one of them now, the Victimless Crimes Act. It's same, and I would say the same thing would apply to prostitution. If you want to sleep with me for money, man, neither one of us is committing a crime. I just don't want to get married again. Okay, so I'll chip in. I'll chip in here. But the other is that the whole problem with our legal system and political system is that they have the royalty, the titles of nobility have taken over both their legislature, our legal system, our judges, and the political system. All these lawyers, and that's British accredited registered attorneys, right?
Well, I don't really subscribe to the theory thing about the British accreditation registry. The thing that's important really is the fact that all the state bar associations basically have an illegal monopoly over the court system. And the main problem is you have the foxes guarding the hen house. If the attorneys don't play ball with the good old boy network, they will get disbarred. They're absolutely terrified of the judges because the judge has the authority to disbar them. And the prosecutors are members of the bar, and the judges are members of the bar. They're all members of the same bar, and they are an independent agency. They're not really, they call themselves like the Washington State Bar Association, but they're not really part of the state. Otherwise, if they were, they would be required to have their main office at the seat of government in the capital in Olympia. They wouldn't have their head office in downtown Seattle. And then 2, they would have somebody in charge of it that we would vote in the office that would be accountable to the public. We have nobody accountable to the public. So we have a private corporation that has an exclusive monopoly over the use of our courtrooms, and they're making money ripping off the rest of us by misinterpreting the law. This is why they're after me for, quote, unauthorized practice of law, because I'm not a member of the bar, I'm not an attorney, I never went to law school, and yet I hold myself out as being able to practice law and give legal advice and charge money for it. I don't give legal disclaimers, and as far as I'm concerned, they can fuck off. I will do whatever I want to do. Go ahead and charge me, I'll beat the charge. I can brief circles around any Jewish attorney on my worst day and stoned out of my mind.
Now,
I've already beaten unauthorized charges 3 times. I've got 2 cases pending, and one of them was about to I'm gonna tear it wide open. They're scared of it. They don't even want to go to court with me now on it.
You've used the term Jewish attorneys for several times, and every time I've had a run-in with a Jewish attorney, well, you got to sign this contract right now. You got to sign it right now, and yeah. Well, wait a minute. You gave yourself in the contract. You get 15% here, 10% there, and 10% there. I don't. You're only one person. No, you're not going to get paid 3 times. And they went after the one attorney that stood up to this whole Southern Poverty Law ADL racket, and it was Edgar Steele. And they manufactured a charge against him. They got him in prison for the rest of his life right now.
Well, he's not very competent, because if he was a competent attorney, he would have known never to accept an attorney to represent him. See, that's how the court gains jurisdiction over you, Clayton, is when you hire an attorney or accept an attorney to represent you. Have you ever heard of that before?
Yeah.
Have you ever heard the term that everybody volunteers to go to prison, or they volunteer to go to the county jail? Have you heard of that before?
Yes.
You know where that comes from?
Where?
It comes from a case called Argersinger versus Hamlin. Argersinger versus Hamlin basically says, let this be a message to all the judges in the land. There's only one thing worse than ineffective assistance to counsel, and that is having no counsel at all. We will not allow you to send a man to the county jail or to prison unless he's represented by a lawyer at trial. That's the key thing there. And you got to go read, besides the Argersinger versus Hamlin case, you have to read the Ferretta case. When you read the Ferretta case and the Argersinger versus Hamlin case, and then you read the Sixth Amendment, and then you read your state constitutional provision regarding that's similar to the Sixth Amendment, you'll understand there's no such thing as a right to be represented in the Sixth Amendment. Now, I'll read you the quote from Argersinger versus Hamlin. The quotation is 407 U.S., page 25, June 12, 1972. And here's the quote, exactly what it says. We hold that no person may be deprived of his liberty who has been denied the assistance of counsel as guaranteed by the Sixth Amendment. This holding is applicable to all criminal prosecutions, including prosecutions for violations of municipal ordinances. The denial of assistance of counsel would preclude the imposition of a jail sentence. Under the rule we announced today, every judge will know that when the trial of a misdemeanor starts, that no imprisonment may be imposed, even though local law permits it, unless the accused is represented by counsel. He will have a measure of the seriousness and gravity of the offense, and therefore know when to name a lawyer to represent the accused before the trial starts. Well, guess what? Go read the Sixth Amendment, and I tell everybody this. Read the Sixth Amendment. Nowhere in the Sixth Amendment does it say that you have the right to be represented. The word represent or represented is not in the Sixth Amendment. Okay, so we're talking about that would violate the rule of statutory construction. First of all, you read the statute as written. Second rule of statutory construction is you cannot add words or subtract words from a statute. You can't read, and the third rule is you can't read words into a statute that aren't there. So this is why the judges make such a big stink